suppose that you're... There's a couple more coming.
3 weeks in town, which is really nice. That's very much the best friends. So I finished luncheon with Bridget's family, and then I was off to Bridget.
Since you're all on time, we'll start. On the 7th of December this year, I issued 11 new practice directions for the Planning and Environment Court. I'll come to why in a minute. So good evening and welcome to this seminar to introduce the practice directions to you, our colleagues in the profession. I acknowledge the traditional owners of the lands and waters of Queensland and around Brisbane, the Turrbal and Yarra people, and pay my respects to their elders, those who have spoken for the land in the past and who do it today. I also want to record thanks to the Chief Justice for allowing us to use the Banco Court for this short seminar. Practice directions are procedural guidelines. Practice directions complement existing legislation, rules and regulations. These are case management practice directions. Excuse me. And so, of course, you don't forget all of the legislation and rules you've read. You might regularly look at the Planning Act, the Planning Regulation, and the P&E Court rules. You might need to look less often at the Planning and Environment Court Act. Section 6 provides that the Chief Judge is responsible for the administration of the Planning and Environment Court and for ensuring the orderly and expeditious exercise of the jurisdiction and powers of the P&E Court. Section 10, called Principles for Exercising Jurisdiction, provides that in conducting the P&E Court proceedings and applying the rules, the P&E Court must facilitate the just and expeditious resolution of the issues and avoid undue delay, expense and technicality. Subsection 2 of Section 10 provides that the parties to P&E Court proceedings impliedly undertake to the court and each other to proceed in an expeditious way. The first part of that, the court's part, is the first reason for the new practice directions. And you'll see reference to Section 10 in the practice directions. The second reason is to respond to feedback from you, the profession. The court enjoys a close relationship with solicitors and barristers who practice in the P&E jurisdiction. Over the last couple of years, there have been opportunities, principally through Queerla seminars and social events, including the fantastic international conference, can't wait for 25, for the profession to talk to judges. I think it's going to be in London. Am I spilling too much information here? Has to be now. It's out. Anyway, sorry, I didn't mean to distract you. Now all you're going to do is think about London. How many times should I say it? Okay. There have been opportunities for the profession to speak to judges and tell us about your concerns, things that you might have, to talk about the court's practice and procedure. And so one of the purposes for the new practice directions is to provide for consistency among the judges and the approaches to different types of proceedings in the court. A second purpose arising from feedback from the profession is to amend the call-over system to provide for more clarity and more time for counsel and solicitors to prepare for allocated hearing dates, and also to allow counsel who practice in areas outside planning and environment to be able to make themselves available to keep in the cases. While the practice directions allow for flexibility, the idea is to set out a consistent approach so that the requirements for preparing a case can be commonly known. The third reason for the new practice directions is simply as a review and modernisation exercise. The practice directions that have been repealed take their lead from a practice direction published in 2006. It was then visionary and ahead of its time and based on laudable ideals that the parties should be encouraged to get a proceeding ready for trial as quickly as they are able with limited court intervention, to encourage ADR to assist the parties with early resolution at a minimum of cost, and to provide a framework of general guidance to practitioners about procedure while maintaining flexibility to tailor directions and orders on a case-by-case basis. So while maintaining these aims, the new practice directions also aim to provide consistent approaches to certain types of proceeding and to ensure that cases are not listed for hearing until they are ready. What seems to have happened is that if hearing dates are allocated before the case is really ready, it compels people to get ready. But if the deadlines are too tight, the preparation isn't complete, and that would occasionally result in hearings taking longer than they should. New practice directions seek to address matters raised by the profession by making it clear priority for hearing dates is founded on a matter being ready for trial, not the day it was allocated to a call-over, when little, if any, steps might have been taken. Spell out in one voice the expectations of the Brisbane judges as to case management and readiness for hearing, that is, again, to provide consistency. And recognise there are different proceedings with different case management considerations and listing requirements to be taken into account. It'll be clear upon a mere glance at the new practice directions that a great deal of work has gone into them. I trust that your representatives who took part in reviewing the drafts and making suggested changes will see the implementation of their work too. And I take this chance to publicly acknowledge the work of the Brisbane P&E judges and thank them for it. In a moment now, I'll ask Judge Williamson to give you an overview of the practice directions. This is designed to be a short seminar, simply introducing you to them. So we're not really going to go into a discussion after that. It's to hit you with the introduction and let you, read it in the holidays. In the new year, we expect and understand and will be cooperating with other seminars conducted by the associations of the practice. Thanks, Mark.
Thank you, Chief Judge. I would like to start firstly with an admission, and the admission is this, that the full suite of practice directions, when you first pick them up, they look intimidating. They are lengthy, there's a lot to digest, and they are prescriptive. However, the read is well worth it in the end. After a few reads, what you will recognise is some old friends. You'll also see some old friends that have had a little work done, an uplift, if you will, and you will meet some new friends. It is my hope that you will see that the documents work together to provide a comprehensive suite of case management measures. And as the Chief Judge has said, the measures are the Brisbane judges speaking with one voice. And the reason for doing so is not just for consistency. That, of course, is highly desirable, but it is to help you assist the court. That is, help you help us. Now, practice directions 3, 4, 5 and 6 refer to a listing judge, and provisions have been made for this in the 2024 calendar. It's structured with the heavy lifting, so to speak, to occur in the P&E applications weeks, and it is in these weeks that case management, applications for interlocutory or final relief, and the listing of matters for hearing will occur. And as paragraphs 3 and 4 of Practice Direction 8 make clear, very little by way of mention or review is to occur in non-application weeks. And the reason for this is essentially twofold. It's to ensure that a trial listed to start at 10 a.m. can start at 10 a.m. It is not delayed by a lengthy mentions list. The second is, as will be clear from reading Practice Direction 3 about the case management streams, that it will give judges an opportunity to deal with cases where they are the supervising judge and they are not listed in an applications week. The number of P&E application weeks for 2024 have been materially increased. There are 18 such weeks starting from the 18th of March. And in round terms, there are about 2 application weeks per month, and I will be sitting in 12 of the 18 weeks. Now, it must be fairly acknowledged from the outset that the implementation of the practice directions is not something the court or the judges can do on their own. The support and cooperation of both branches of the profession is critical. We're in this together. And as the listing judge for 2024, I'm asking you for that support and cooperation. And I'm asking you this for now because it doesn't take much exposure to litigation generally to realise that it's never perfect. No case management system is ever perfect. So there will be teething issues in the first year, and I'm confident we will comfortably navigate this period applying common sense and a pragmatic approach, which is a hallmark of this jurisdiction. Now, it is my expectation that your willingness to support and cooperate with the court will manifest itself principally through a recalibration of your approach to litigation in the court. And you're probably asking, what does he mean by this? When I started in this jurisdiction more than 20 years ago, it didn't take long to see that there are 3 characteristics firmly embedded in the DNA of the court and its practitioners. First, there is a desire to get on with it, assuming everything will be right on the night, with the night being the trial. The second is a desire, and a strong desire, to avoid form triumphing over substance in public interest litigation. And the third, which is last but not least, common sense. Thankfully, these features will still remain a part of our DNA and remain a part of our DNA today. And the new practice directions do not seek to change this. The characteristics, however, we need to bear in mind are not overriding principles. They are not to be applied at the expense of the interests of justice, and nor are they without downside. I explain the downside perhaps in this way, that if you take the let's get on with it, let's get on with the merits approach, everything will be right on the night. This ethos is fundamentally about avoiding delay, but it can be too readily deployed to justify why significant preparatory steps have spilled into the time allocated for a hearing. That is, the trial itself becomes an extension of the preparation period. The importance of substance prevailing over form and adherence to common sense is also obvious. However, these remarks are often deployed to disparage technical points that simply cannot be ignored given the complexity of legislation and the size of modern planning schemes. We are, and when I say we, in fairness, that is both practitioners and judges, are in a sense conditioned to really justify often poor preparation for a hearing on the basis that all delay is bad, we need to get on with it, get on with the merits and avoid complexity. The difficulty or the danger is that the pendulum is allowed to swing too far one way. And allowing the pendulum to swing too far one way has an impact. It impacts on a solicitor and barrister's ability to properly prepare for a hearing. My own experience at the bar was that counsel's preparation time was always compressed. It was compressed in the name of a desire for a quick hearing and to avoid delay, or to pay for the sins of the past, which are informally known as slippage. Now, the new practice directions are about recalibration. What this means, in my view, is encapsulated by two words: breathing space. It's to provide breathing space at specific times in the preparation process to allow you to measure twice and cut once. But not only measure twice and cut once, but do it at a time where it really matters. Breathing space will also provide balance. It will keep in check the notion that we just get on with it, irrespective of the state of readiness for a hearing. Now, not all proceedings require the same breathing space, and this is why the practice directions have been prepared for three types of proceedings, along with a practice direction for listing. Each of the specific practice directions ascribe a high value to breathing space and contain measures to protect that space. They also make clear what should or should not be assumed if a party fails to use the breathing space wisely. In this regard, breathing space should not be confused for free time, nor should it be seen as extending an invitation to our collective enemy, delay. Now, practice directions 3, 4 and 5, to which I'll turn shortly, identify particular tasks that are to be completed during these periods to assist the court. Now, one example of breathing space is the combination of the definition for ready for hearing with the new timing for callovers. A callover will now be 6 weeks rather than 2 weeks prior to the commencement of a sitting. Now, this will give you more time to prepare for a hearing before it commences. That is breathing space. The integrity of this time is protected by the ready for hearing definition. Save for exceptional circumstances, a proceeding that cannot satisfy the definition will not be allocated hearing dates. The 6-week period will thus be preserved. It will not be truncated absent exceptional circumstances. Now, as a side note, you should not think the exceptional circumstances test is new. It has formed part of the court rules since at least 1999. The test is stated in Rule 21.3, Sub 3 of the Planning and Environment Court Rules 1999, which took effect during the currency of the Integrated Planning Act 1997. That test, but not in identical terms, it remains in the current rules today. Now, turning to matters of detail, I'm not going to walk through, you'll be happy to hear, given it's 5:30 on a Thursday night, I'm not going to walk through each of the practice directions in order and paragraph by paragraph. I'm happy to do so, but that's perhaps a reflection on my level of excitement rather than the potential interest of the audience. But what I intend to do is deal with them in 3 groups. The first are the practice directions having immediate effect. Second group are those with a delayed start, that is the 18th of March, and relate to specific proceedings. And the final group are the practice directions with respect to referral agencies and self-represented litigants. These are, the last 2 are what I would regard as some of the new friends. Now, the practice directions having immediate effect, 3 of the 11 have immediate effect. Practice direction number 2 and practice direction number 8. They are old friends and apply to new and existing proceedings in Brisbane. So number 2 deals with the early resolution or determination of appeals about an infrastructure charges notice or development approval conditions. Now, it's had a little work done. It contains 2 updates from what appears in Practice Direction 7 of 2013. First, unsurprisingly, the reference in the former practice direction to the Sustainable Planning Act and its associated charging regime has been updated. Second, the practice direction now admits of the opportunity for parties to pursue private mediation in lieu of attendance upon the ADR registrar at an early stage. Excuse me. Practice direction number 8 is also an old friend with a little work. It deals with reviews, applications and orders on the papers. Save for one change, they are consistent with the counterpart arrangements in place under the repealed practice directions. And the change is that the practice direction now seeks to direct particular reviews and applications away from non-application weeks, and this, as I've said, is reflected in paragraphs 3 and 4. As to what type of matter is directed away from a non-applications week, I think in the early days there is going to be a handy rule of thumb. If in doubt, list the matter in the applications week. Practice direction number 9 has also taken immediate effect. Again, you will see on close examination it is an old friend. It relates to the powers conferred upon the ADR registrar, and it collects provisions from practice directions 1 and 2 of 2020 and puts them into one practice direction. The practice direction 9 also includes one point of clarification. Paragraph 11 clarifies that the ADR registrar can list a proceeding for a review where all relevant preconditions are met but for one, and that is where the review date would fall outside the 1 month limitation period. This point of clarification is that the ADR registrar can list the matter for the review outside the 1 month limitation period, but only where that is because of a court vacation or because of the listing practices in a registry outside of Brisbane. And the date for review must be the next available date after the expiration of the 1 month period in any event. Now, the practice directions with a delayed start, that is effectively all practice directions save for 2, 8 and 9, they will not commence until the week of the 18th of March 2024. So why the delayed start? Draft versions of the practice directions were provided to the Bar Association and Queensland Law Society for feedback. The QLS, who expressed support for the practice directions, suggested their adoption should be delayed to give the profession an opportunity to digest the documents and for training to be provided. This sensible suggestion was adopted. The 18th of March was selected because it gives a period of 6 weeks from the start of February, being the point at which the bar finally returns from holidays. And it gives the profession that time to read, digest, and in some cases, test drive the practice directions before the rubber hits the road. And I can say, at least from a mention on Wednesday, test driving is already underway. Now, as to the practice directions with a delayed start, they can be dealt with in 2 tranches. The first are those practice directions 3 to 7, which are the types of proceedings and listing for hearing. And the second tranche are practice directions 10 and 11, which relate to referral agencies and self-represented litigants. So dealing with practice directions 3 to 7, the best starting point is practice direction 6, which deals with the listing for hearing. That practice direction provides that a proceeding will be managed and listed for hearing in one of 3 streams: the ready for hearing list, supervised case list, and the call over system. The ready for hearing list is a new friend. A proceeding will be eligible for that list where it involves a hearing less than 5 days, and it will be ready for hearing within 12 months from the date of filing. Now, assuming the listing judge is defined is satisfied it is appropriate to do so, a proceeding will be allocated to this list on what is called the first return date. It is on this date that issues with respect to service and directions generally will be dealt with. one of the directions that will be made, if allocated to the ready for hearing list, is one with respect to a pre-hearing review. And this is the review at which the fixed dates would be given for the matter on the ready for hearing list. Now, the intention is that the matter after the first return date, and that is after directions have been made, is going to be self-regulating with a full suite of directions. So for extending time due to slippage, future contact with the court, the anticipation is will be kept to a minimum, that is prior to the pre-hearing review. At the pre-hearing review, readiness for hearing will be assessed by the listing judge. If this is demonstrated, as I said, the proceeding will be given fixed hearing dates. Those dates will not be constrained to a sitting. Counsel availability will also be taken into account when fixing the dates. That is a new friend that the bar, I suspect, will like. When given trial dates, the proceeding will also be listed before the hearing judge for review. It is at this review orders will be made to tailor a matter to the specific requirements of the hearing judge. So, for example, this is where you could expect an order to be made by Judge Everson about the delivery of an agreed list of issues. Judge Kefford may make an order about a matter being conducted as an e-trial. Judge McDonnell and I may make orders about the delivery of a written opening or case synopsis. These are just examples and may not be ordered in every case, but they are the types of orders that are intended to be made at this point, as I say, to tailor the matter to the requirements of the hearing judge. Now, the second case management stream is the supervised case list. This is an old friend with a new name, formerly known as case management. The purpose of the list is to facilitate the resolution and determination of proceedings that require more intense management than other matters. And can I say it's not limited to proceedings that will require a hearing for 5 days or more. The practice direction 6 spells out matters to be considered for inclusion in the supervised case list. It includes complexity of the matter, the number of issues, number of parties, number of witnesses. It is not limited to those considerations. A proceeding will be added to the supervised case list by the listing judge. Ordinarily, directions will not be made by the listing judge. It will be left to the allocated supervising judge. And it is for the supervising judge to manage the proceeding up to the point he or she considers it ready for hearing. It is at this time it is returned back to the listing judge for the allocation of hearing dates. Now, paragraphs 22, 23 and 24 set out that a matter that is on the supervised case list may be given fixed dates or placed on a call-over. Now, whether a proceeding is on the call-over or given fixed dates is going to be considered having regard to, amongst other things, the age of the proceeding, that is calculated from the filing date. A proceeding older than 12 months ordinarily will not be given fixed dates. Adjourning a proceeding of this age also from one call-over to the next should not be assumed as a given, nor should it be assumed that counsel's availability will necessarily be accommodated for a proceeding that is older than 12 months. But one needs to be careful with the use of the word ordinarily in the practice direction. There are likely to be lengthy matters which are the exception to the rule, which may necessarily require fixed dates given their size, complexity, the number of witnesses and the need for a calendar change. Like the ready for hearing list, when the hearing dates are allocated for the matter the subject of the supervised case list, the proceeding will be reviewed before the hearing judge. The third stream of case management is the call-over system. Again, an old friend with a little bit of work. The work is, as I've mentioned, the change to the call-over date. So there is a longer runway from the time hearing dates are allocated to the start of the hearing. There is also going to be a reduced number of sittings. So there are normally 1 per month. There are going to be 10. And that's achieved by rolling the first week of December into the November sittings. So that what was the November sittings is going to be a week longer. And in January, the week in January is going to be rolled into February. So it picks up another week. Now, the 12-month mark again marks the change between whether or not something will be adjourned from call over to call over, whether council availability should be necessarily a determining factor. Now, the dates, once they're allocated, again, at the call over, you'll be sent for a review before the hearing judge, who will then make directions about tailoring the matter to his or her preferences. Common to all three streams is the requirement to meet the definition of ready for hearing. Now, the definition is to be found in the practice direction applying to the particular proceeding type. Given what I've said about breathing space, you should assume these definitions will be applied to each and every proceeding captured by the practice directions. I wanted to comment about particular aspects of the definition. The definition requires an affidavit to be filed that deposes to certain things: compliance with the rules, compliance with directions. It also requires that it be deposed to that ADR has been exhausted and there are no minor changes or further minor changes proposed. Now, swearing to compliance with court orders and the rules as at the date of the affidavit will be straightforward enough. Swearing to matters about exhaustion of ADR and minor change do come with some difficulty in that you're going to be asked to do that in advance of the hearing. The affidavit that is filed cannot swear to a change in circumstances that are unknown. That is, circumstances which may trigger or be the impetus for further alternative dispute resolution, settlement or a minor change. The purpose of the statement in the affidavit is to swear on the information available at the time that ADR, to the best of the deponent's knowledge, has been exhausted, and that minor change, if necessary, has been pursued and itself exhausted. The idea is that these two matters have been pursued and the listing judge is made aware of this before a matter is listed for hearing. Now, turning to practice directions 3, 4 and 5, they are directed to specific proceeding types and the particular case management principles applicable to each. Now, practice direction 3 is the merits practice direction, which is, of course, the bulk of the court work. And can I suggest to you that it's perhaps helpful to look at the practice direction as identifying 3 particular stages from the filing of a proceeding to the commencement of the hearing. And it draws what might be regarded as clear lines between at the first return date, and it draws a line at the time where hearing dates are sought. So there is a period from the commencement of the proceeding to the first return date. There is a period of preparation after the first return date to the time hearing dates are allocated. Then there is a third period of time, which is once you've got your dates, what happens from there. If you focus on the first period, that is leading up to and including the first review date, you will see that there has been a departure from existing practice. It now speaks of a period of 3 months for bringing the matter before the court in lieu of 6 weeks. This is to achieve consistency with the rules. The Planning Environment Court rules speak of a period of 3 months, not 6 weeks. It's also intended to provide the breathing space that I referred to. It is in this period that parties will be assumed to have put their house in order. It is not dead time. And the best illustration of this is paragraphs 14 and 15 of the practice direction, which speak about a refusing party and perhaps a council who wishes to augment its reasons for refusal or take steps to change its case beyond what appears in the decision notice. The idea is that this 3-month period is to be used to get those things in train, to get the house in order, so that at the first return date, orders are not made simply, we'll see in a month's time, wait for someone to work out whether they want to amend their issues or not. That should already be attended to. That's not to say that it may not trickle over beyond the first return date, but that will need to be explained. What steps have been taken? What needs to happen or what steps will happen for issues to be finally crystallised? Before the first return date, there needs to be time also for the decision maker to, amongst other things, file the certificate or affidavit referred to in the practice direction. And the practice direction speaks of any first return date allowing about 10 days for the decision maker to deal with that affidavit material. The purpose of, or certificate I should say, the purpose of the certificate or affidavit is, amongst other things, to assist the listing judge to decide which stream to allocate the proceeding to. So it puts information before the listing judge to think about things like, this is a childcare centre case. It's in the low density residential zone. Is there a neighbourhood plan that applies? It allows a sense of what the case might be about to be appreciated by the listing judge. The practice direction also speaks about the provision of draft orders, and that is an old friend. We know about the provision of draft orders and the need to comply with the rules. Although the practice direction now speaks of compliance with the rules representing a minimum, that is not to be seen as gold standard, but this is the minimum time that notice should be given of draft orders to your opponent. And why is that? Well, firstly, it's a matter of professional courtesy, because it is evident from, at least in my experience, sitting in mentions, watching the exchange of draft orders behind the bar table. It's late notice. Now, in my time in practice, I was as guilty as anyone else handing over late orders. But the real difficulty with it is it impedes the ability for your opponent to obtain proper instructions. It impedes the ability to obtain proper instructions. And what that will do is will impede the ability to make decisions on the first return date that allow the proceeding just to continue, as opposed to having to return to deal with things piecemeal. It's about avoiding or reducing the amount of times the court has to touch the file, which in turn reduces the amount of times the practitioners have to touch the file. That, I suspect, is that is an attitudinal change which hopefully will start to take effect sooner rather than later. Practice direction number 4 is about judicial review or declaratory proceedings. And a point to note is that now there is a requirement, or there will be a requirement, to obtain your return date for that application on filing. It is not to simply sit for the 3-month period and wait to be brought to the court. You need to obtain your return date. The practice direction itself, when considered, you will see it also sets out a sequence for proceedings of this character. The sequence is set out in paragraph 9, and in general terms there are 4 elements to the sequence. The first sequence is not first step in the sequence is not the preparation of statements of facts, matters and contentions and replies, which in the past have only served to do one thing: confuse the case. The first step is for the decision maker, whoever that might be, to prepare the bundle of documents that was before the decision maker. That is the first step. Once that has occurred, then the second step is for the applicant to file its material and file its written submissions that it will seeks to rely upon. The third step is for the respondents to file their material and to file their written submissions that they wish to rely upon. The final step is a reply. Now that's collecting a number of steps into four, but that is the broad sequence. As to the provision of orders and listing of judicial review of declaratory proceedings, the provisions of Practice Direction 4 are essentially identical to Practice Direction 3. There is perhaps one additional thing to note about Practice Direction 4, and that relates to objections to material, affidavit material. And you'll see within the Practice Direction, it's identified that in proceedings of this character in the past, experience has shown that a lot of affidavit material is filed and it is potentially inadmissible because it goes beyond material before the decision maker. The Practice Direction encourages the parties to get to the bottom of those objections to ensure that rather than having in the Riverside case, I think I had something like 17 lever arch volumes of material, of which about 4 of it was ultimately admissible. We get to what the real bundle of material is, and we focus on that, and everyone refers to the same bundle of material. Equally, it will flush out where affidavit material is relied upon for one of the exceptions to where extrinsic material might be admissible, so that parties are put on notice about that. Practice Direction 5 deals with proceedings with an enforcement component or similar. And again, note that there's a requirement to obtain a filing date when a proceeding of this character is commenced. A particular sequence is also spelt out in the Practice Direction in paragraphs 10 and 13. In broad terms, the sequence is this. The prosecuting or moving authority who is alleging an offence or breach of an act goes first. It spells out its case in its pleading, it puts on its affidavit material, and makes complete disclosure of why it contends an offence has or will be committed. The matter will then be brought back on for review before the listing judge. And it's at this point that the respondent will be asked to make an election. That is, will they go into evidence? Will they file written submissions? Is it going to be contested? But that election is not extracted from the respondent until it has had the advantage of seeing the case against it. Again, the provision of orders and listing arrangements for these proceedings are identical to Practice Direction 3. Practice Direction 7 deals with written submissions for applications, minor changes and contested hearings. You will see that the Practice Direction provides for now a default setting. Save for an order of the court, written submissions must be filed and served as early as practicable before a hearing. This is a change to practice, and the default position puts the onus on the legal representatives, particularly counsel, to have submissions either ready at the commencement of the hearing or to ensure they've turned their mind to an alternative arrangement in advance of the hearing and taken that up with the hearing judge. Each of Practice Directions 3, 4 and 5 make provision for alternative arrangements to be made with the hearing judge. For example, an order could be made about a timetable for the exchange of submissions after the close of evidence. Another example could be an order where submissions are delivered in parts, like they were in the landfill cases, a Part A and a Part B. Part A was delivered before the start of the case. It set out an introduction, They set out an introduction, information about the land and surrounding area, statutory assessment regime and the issues. Part B was not to repeat Part A. It addressed the issues that were identified in Part A and were delivered after the close of evidence. But again, it was an arrangement that was struck before the start of the hearing rather than the hearing judge being left in the dark as to when counsel will deliver written submissions. Will they be exchanged? Will they be in a form that will assist the hearing judge? Now, there are particular aspects of the practice direction that I will point out, and the first is perhaps, I won't say trivial, but it's formatting requirements. Paragraph 4 and footnote 2 deal with the formatting requirements for written submissions. Paragraph 4 sets out the spacing, the font type, and the size of the font. Footnote 2 is related specifically to the schedules which are attached, which I'll get to in a moment, and they speak of the formatting being such that it is legible. I think it's safe to say I can speak on behalf of all of us. We don't want to see the schedules in A4 size with print so small that it is illegible. They are designed to be at A3 size so you can read them. Please also note in the document the times by which submissions are to be delivered to the court. 2 p.m, the business day before interlocutory applications, and 12 p.m, the business day before applications for minor changes. These are not typographical errors. They are deliberately selected. More time is required on our side to read the material for minor changes, particularly where it involves the change to a development approval. And while I'm on the topic, can I say that when you're preparing an estimate of time for an application to change an approval, I think I can confidently say they don't take 30 minutes. Not one takes 30 minutes. They generally take, just in reading time, about an hour, if you're lucky. And that's moving through sometimes very significant volumes of material. In any event, I digress. Submissions are to be provided for all minor changes, and the submissions are to be accompanied by a bundle of plans. Now, that doesn't mean every plan. It's plans sufficient to demonstrate the changes, and in relation to submissions that deal with changes to approvals, they also need to address specific sections in the Planning Act. Now, a new friend appears at paragraphs 24 to 32 of Practice Direction number 7, and the friend relates to written submissions for a proceeding where non-compliance with the planning document is in dispute. Paragraph 25 of the Practice Direction identifies what the submissions must address in those circumstances. And they must identify the provisions or part thereof of the adopted or draft planning instrument in issue in the appeal. They must identify those provisions or parts thereof of the adopted or draft planning instrument for which non-compliance or compliance is conceded, and explain the weight to be attributed to these provisions. It must make submissions where required about the proper interpretation of each provision in issue, particularly where they contain compound propositions. That are explain why non-compliance or compliance, as the circumstance requires, arises with each provision in issue. It's to identify the evidence relied upon to establish compliance or non-compliance with each provision in issue, and provide analysis of the evidence, and where relevant, explain why evidence relied upon should be preferred to other contrary evidence. Now, all that might sound like a mouthful, but when you read paragraph 25 of Practice Direction number 7, that is precisely the exercise that the hearing judge must do. It is up to the trial judge, I can say for my own part, goes through that very exercise, identifying what are the provisions, where are they, what's the evidence relied upon in support of one or the other? Why should some evidence be preferred to other contrary evidence? Paragraph 26 helpfully tells you what will not pass the grade, and that is a submission that simply asserts compliance or non-compliance with a planning provision by simply repeating the words of the provision itself. That is completely unhelpful. An issue about non-compliance, absent reference to or analysis of the evidence, is of little assistance. Now, to assist the written submissions in complying with paragraph 25, paragraph 28 provides for the preparation of schedules part A, B and C. And you will see the headings in each of those schedules go to the very matters in paragraph 25. Draft versions of the schedules must be completed to satisfy the ready for hearing definition. And when you look at the schedules that are attached to the practice direction, you must bear in mind that those drafts represent what the final product would be. The draft itself will not include the exhibit numbers like the schedule attached to the practice direction. Where columns are to be completed in each schedule at the draft stage, the reference will be to the actual document itself until the exhibit number is known. So it is anticipated clearly that these schedules will be updated as the proceeding progresses, from, at the very least, demonstrating ready for hearing before the review before the hearing judge, and the schedules that are attached to the written submissions at the end of the case. Can I say, for my part, it's going to rely upon the schedules to do most of the work lists of issues for me were expected to do. They will identify what planning provisions, including their parts, which are an issue, and why non-compliance cannot be conditioned. The schedules will also identify whether COTI is in play or whether draft amendments are going to be relied upon as contending a planning scheme has been overtaken by events. The schedule will flag these things early. The schedules are also intended to remove the duplication of planning provisions in multiple sets of submissions. The idea is that reference would be made to the schedules themselves rather than repeating particular parts of the planning scheme in the written submissions. Now, to be clear, the practice direction 7 does not require written submissions for each and every interlocutory application. For these matters, use your common sense. If an application calls for the exercise of a discretion, written submissions are usually delivered and they assist the court. If the matter is about uncontested directions, a first review date with directions that are without complication, written submissions are not expected, at least on my part. Practice directions 10 and 11. These are, as I've referred to, they're new friends. Practice direction 10 is about referral agencies, and it is intended really to tidy up two things. Firstly, the steps that have taken to seek excusal from active participation, and to ensuring that we all, not just practitioners but the court, remember to keep referral agencies in the loop where there is a change in circumstance that may touch upon the referral agency jurisdiction, be it direct or indirect. Now, excusal from participation, active participation, is self-explanatory in the practice direction. An affidavit is called for setting out a number of things, including that particular instructions have been given that the change in circumstance does not, or the proceeding does not give rise to an issue that the referral agency will contend for refusal or wish to be heard. As to notice that is given to a referral agency who is not a party or does not take an active role in a proceeding, paragraph 5 of the practice direction spells out that there are a number of triggers. and that may, subject to the circumstances of the case, require notice to be given to that referral agency. Not every trigger will require notice. The practice direction simply requires the parties to draw the existence of the trigger and the referral agency's jurisdiction to the court's attention. The idea being that the court will decide whether the agency should be given notice, having regard to the change in circumstance, and make orders accordingly. Where notice is required to be given to the referral agency, you'll note that paragraph 7 speaks of encouraging but not directing the referral agency to respond within 10 business days. Practice direction is about self-represented litigants. The practice direction requires someone who is or becomes a self-represented litigant in a proceeding to inform the ADR registrar and the list manager. They will in turn, within 5 business days, be given a kit. The kit is the self-represented kit, and it includes a copy of, amongst other things, the practice direction itself. In the practice direction, we are asking for the assistance of practitioners. It's not a direction, but we're seeking your assistance that if we do not want self-represented litigants falling through the net, you're encouraged to inform the ADR registrar or the P&E list manager if you become aware or you know a party is a self-represented litigant who's not given the required notice. This is to ensure that that litigant receives the self-represented litigant kit and the practice direction, which includes the practice direction more accurately. The practice direction itself is intended to address some issues that have arisen with self-represented litigants in the past. The practice direction, as a start, sets out what is expected of self-represented litigants with respect to communications with the court and when their appearance is required when a proceeding is listed for a review or hearing. It also identifies that the process for seeking leave to appear by telephone, and it is often the absence of self-represented litigants it mentions that is a considerable source of frustration. A difficulty that has also arisen, particularly I have seen in recent time, is where self-represented litigants appoint an agent to act on their behalf for all or some of the proceeding. The practice direction includes a new form for the appointment of agents by self-represented litigants, and the forms will need to be signed and filed. They will be read at any review or hearing by the agent. The purpose of the form is to standardise how self-represented litigants appoint agents, and it's to avoid really an all too common situation, and that is a lack of clarity about who, when and for what purpose an agent has in fact been appointed. It is in all parties in the court's interest that this is clear. It avoids orders being made unwittingly in the absence of a party, particularly final orders. All of the practice directions that the Chief Judge has signed, save for number 9, apply or will apply in Brisbane. They reflect the Brisbane practices. They may be adopted in whole or part in other registries, and it is a matter for the judges in the other registries as to what, if any, parts of the practice directions they adopt. As to the transition from where we were prior to the 7th of December and the 18th of March, the practice directions will be applied to existing proceedings in this way. If no step has been taken, you should assume that the practice directions will be given their full force and effect for a proceeding commenced after the 18th of March and any existing proceedings still on foot. Now, if no step has been taken, no step we take to mean excluding adjournments and without prejudice conferences. If a step has been taken in an existing proceeding, the practice directions will be applied with necessary adjustments to reflect the circumstances of the case. Now that is, I cannot catalogue for you tonight what that will look like for each and every proceeding. But what can be said, or what I can do, is give at least 2 examples. If you take a proceeding which prior to the 18th of March has been case managed, to use the old terminology, from the 18th of March it would be treated as if it were included in the supervised case list, and the case management judge would be the supervising judge. A further example is the ready for hearing definition. That will be applied to a proceeding that has not been listed for hearing prior to the 18th of March 2024. That is, the trial need not be before the 18th of March. It is the date it is listed that will be the focus. This again, as I've already said, is to start to entrench breathing space and the shift or the recalibration of which I've spoken about. As to each and every example, as I've said, we cannot catalogue what they may be, but I go back to where I began, and that is asking for your cooperation and support. In the first 12 months in the implementation period, there will be teething issues, but adopting a common sense and pragmatic approach, I'm very confident that the profession, in concert with the judges, will work through that period. Now, this was a high-level tour through the practice directions. It goes without saying, but I'll say it anyway. You need to read them. I have. And as the listing judge in 2024, I will be applying them. You will need to know them. I will expect that you know them. I look forward to working with the profession in 2024 and implementing the practice directions. Thank you, Chief Judge.
Thanks, Judge. It's good at this time of year when you're getting tired and still really busy to know that there are friends, old and around the corner. Thank you very much for coming at 5:30 on a Thursday afternoon at this time of year when you're still really busy and probably really tired. But it was really worthwhile to do. It's a big set of work, and it's good to at least have that introduction to it. I withdraw the silly remark I made before about reading them on the holidays. You're not to read on the holidays. Okay. You're not directed to read on the holidays. Thanks very much for coming, and good night.